Selamat pagi.
Hai, selamat pagi. Okay. In this evening, the General Stadium will opened by our President of University, the Vice Rector of Bengkulu University, Ueda-san.
はい。
はじめまして、上田先生。
こんにちは。こんにちは。
こんにちは。よろしくお願いします。
先生、アマンシック先生ですか？お名前
ルフィ。
お名前
私の名前はルフィです。
ルフィ。
はい。
ルフィ。
ルフィ。はい。
ルフィ先生、はい。インドネシアの、こういう機会を与えていただきましてありがとうございます。
いえ、こちらこそありがとうございます。
先生、日本語おできになるんですか？
私は、京都大学で、卒業しました。
あ、そうですか。何年ぐらい、
はい、
何年ぐらい日本にいたんですか？
その時は3年間。はい、3年間。
そうですか。素晴らしいですね。私はもうインドネシア語は全然できませんので。
いえ、さっき言いました、先生。はい、どこに住んでいますか、先生？
今、札幌にいます、北海道の。
ちょっと寒いですね。
はい、でも今は夏なので、とても暑いです。
何点ぐらいですか、今？
今は28度ですかね。
まあ
でも、インドネシアに比べると、そんなに暑くないと思います。
そうですね。35点ぐらい、ここ。ブンクルは。蒸し暑いですか、札幌？
ちょっと蒸し暑い、ヒューミットですね。
はい。わかりました。Prof Ramani, silakan. ちょっと日本語を勉強しています。
Professor Luti, the graduate from Kyoto University in doctor course, of course. Very young, and he now maybe he likes to open, and I'm very glad because he speaks Japanese too. Maybe this make very familiar for Ueda sensei. Okay?
ルフィ先生の専攻は何ですか？何を勉強されてたんですか？
専攻は何ですか？ちょっと。
スペシャライゼーション。
科学、海洋科学です。
海洋科学？
はい。
すごい。
So I was graduated from Kyoto University in 2007 in marine chemistry. And I've got a Monbuso scholarship.
Really?
Yes, for 3 years PhD there.
Maybe we start now. Of course, wait until the another participation. Okay.
Okay.
Should we proceed?
先生、ハランバンさん、今日ウェルカムスピーチってアマンシック先生がやるんです。
Professor Luti, Vice Rector.
Really? Okay.
Right. Okay, Ari, we can start now.
Thank you so much for offering the microphone and the share screen to me. First of all, very good morning, ladies and gentlemen, and also all participants and all students of the Master of Law, Faculty of Law, Universitas Bengkulu. The Honorable Mr. or Professor Sintaro Ueda, the professor at the Hokkaido University, as well as the honorary professor at the Okayama University. His Excellencies also the Professor Dr. Muhammad Lutfi Firdaus as the Vice Rector for the Academic Affairs, Universitas Bengkulu, and also the Honorable the Professor Dr. Herlambang Eshaimha as the Chairman of the Graduate School of Faculty of Law, Universitas Bengkulu. Today, we have the annual event that organized by the Faculty of Law, Universitas Bengkulu, particularly the Graduate School of law regarding the stadium generally on the Japanese criminal law and the procedure. So without further ado, first of all, I think that it is such an honor for me. My name is Ariwirya Dinata, Hajime Masite Watashiwa Ariwirya Dinata Des. I'm the junior constitutional law lecturer at the Department of Constitutional Law at the University of Bengkulu. Today, before we going to the main topic or main discussions or presentations by Professor Sintaro Ueda, I think that first of all, Indonesia's government and also Indonesian society, particularly the Universitas Bengkulu and the Faculty of Law, want to convey our highest and coolest condolence for the tragedy of PM Shinzo Abe or Prime Minister Shinzo Abe. I think that the Indonesia and the Japan, after the independence of Indonesia, have the good relationship. So what happened in the Japan right now is also the concerns and also the attention of the Indonesian government itself. So without we proceed our event today, I would like to invite all the participants to do the moment of silence in 30 seconds before we move to the next event. So moment of silence begin. Moment of silence, done. Okay. Well, ladies and gentlemen, and also all the participants, to proceed our event today, I will over the microphone and also the share screen to Professor Dr. Muhammad Lutfi Firdaus to convey his remark and also open officially our event today. To Professor Dr. Muhammad Lutfi Firdaus, time is yours.
Okay, thank you, Ari, SMC. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Firstly, I would like to thank the Faculty of Law, Bengkulu University, chaired by Professor Helambang from Magister Hukum, and all organizing committee who routinely carry out academic activities such as today's Stadium General seminars with the topic of Japan criminal law and procedure. Thanks also to the honorable keynote speakers, Professor Sintaro Ueda from Hokkaido University, and also from Honorary Professor of Okayama University, who has been pleased to share his knowledge with the academic community and all audience. Today's seminars are an opportunity to disseminate the latest research results from keynote speaker, which should be exploited by students and audience. Some study program in University of Bengkulu itself will soon reaccredit with an unggul or superior target. I believe this seminar will further convince the assessor of BANPT to give the best result on the accreditation. Okay, without further ado, by saying Bismillahirrahmanirrahim, I officially open the Stadium General. Hopefully, we audience and students can take a lot of benefits and knowledge from the keynote speaker's speech. Happy seminar, everyone. Stay safe and keep healthy. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much for the welcoming speech made by the Professor Muhammad Lutfi as the Vice Rector for the Academic Affairs, Universitas Bengkulu. So without further ado, I will invite the moderator today, Professor Dr. Herlambang, to lead the discussions and the presentations that will be making or presented by Professor Sintaro Ueda. So without further ado, the microphone and also the share screen I offer to Professor Herlambang.
Okay, before we start the general stadium, maybe Professor Ueda Sensei will speak some for before give the presentation. That's you will speak something, please.
Selamat pagi. Nama saya Ueda.
Hai.
Apa kabar?
Sehat.
Senang bertemu dengan Anda. Unfortunately, I don't speak in English. I don't speak in Indonesia. So from now on, I want to speak English. So sorry. First of all, I'd like to express sincerely thank you very much for your heart and warm words from Professor Ali Viruya and Luffy Sensei, Professor Luffy, and thank you very much from bottom of the heart. And of course, thank you very much for Professor Harambang, my friend. Without Harambang's cooperation and the management, I couldn't have a lecture this time. So I really express sincere thank you very much for all of the students, all of the professors and the students of Bengal University. Of course, it is a very honor and a pleasure to have a lecture in this time to the student of Bengal University. If my lecture interests you, the Japanese criminal law and the criminal procedure law, I will be very happy. Now, today and tomorrow, I want to use PowerPoint to explain about the lecture, to proceed my lecture. So please wait a minute. I want to share my PowerPoint material. Please wait.
Okay, thank you, Prof. Eda. Professor Rufti, if you have any ceremony or some job, no problem if you like to leave from this meeting. Thank you very much.
Okay, thank you so much. Okay. Bye-bye, Ueda Sensei.
さよなら。ありがとうございました。
さよなら。
ありがとうございます。よいしょ。No. ここからだ。よいしょ。Do you see, can you see the material?
Okay, yeah. I see the beautiful campus, you know?
Yes, thank you very much.
Okay.
As I said before, I want to explain and proceed by using PowerPoint from now on. Again, I thank you very much for giving me a very nice lecture, very nice opportunity to have a lecture today. First of all, today is I want to explain about especially criminal code in Japan. Okay. Before explanation of criminal code in Japan, I want to touch upon the Hokkaido and Hokkaido University a little bit. As you see, there's a Japan map. The Hokkaido is here, the north of Japan. So, and here is Tokyo, is a capital of Japan. It is a very famous city. And population in Hokkaido, Hokkaido is it's about 5.2 million people living in here, and the population in Sapporo city about 2 million. The Sapporo is here, is in here, and the scale of cities of Sapporo is 5th in Japan in terms of population. The scale. First of all, the first position is, as you see, as you know, Tokyo, the capital of Japan. Tokyo is here, and Yokohama, and Osaka, and Nagoya, and Sapporo, and Fukuoka here. So Sapporo is relatively big cities when it comes to comparing with other cities in Japan. And this is the main street of Sapporo city. And so-called Odori Park. It is very famous for tourists in Japan. Of course, not only Japanese tourists, but also foreign countries, foreigners. Nowadays, the tourists from Indonesia is lots of tourists from Indonesia is coming here to sightseeing. But of course, now because of COVID-19, there is a few tourists, foreign countries. But of course, if the end of the COVID-19, probably many foreign tourists come to Japan and come to Hokkaido, I think. And as I said before, the Hokkaido is north of Japan, so in winter there is a lot of snow. This is the same place on Odori Park. As you see, here is very snow. There are lots of snow. So of course, Indonesia, you don't have snow in winter. In winter season, from especially Eastern Asia, from foreign tourists come to Hokkaido to see snow. And this is the snow festival. It's a famous festival in Sapporo. And this is building of the paradise made by snow. It's about 2 million people come to Hokkaido in this winter in this winter season to see snow festival. And this is a museum of our university in winter season. This is a very famous place in our university. Exhibition is, for example, dinosaur or several departments studying resort. We can see that. This is a library of our university in summer season, so there is no snow. Yeah. This is the main place and the main park of our university. Our university is a very big scale in Japan. Of course, the biggest scale in Japan, biggest scale. Hokkaido University has the biggest in Japan. So there is a river and forest we have. Okay. Now, first of all, I will explain about, I will say my self-introduction. I will introduce myself at first. My studying field is criminal procedure law, especially criminal evidence. I'm studying the criminal evidence and the confession of defendants and suspect. The confession means, of course, I did commit I committed the crime. That statement of the defense or the suspect, the saying is a confession. And corroborative rule. It is very explained. It is a little bit. It is very difficult to explain a little bit. But later on, tomorrow, I want to explain the content of the corroborative rule tomorrow. And the work experience is the first of all, 1992. I became a lecturer of Kagawa University Faculty of Law. At that time, I met the Professor Haramban. It's about
6. Okay.
And April 2003, I transferred from Kagawa to Okayama University, professor of Okayama University Faculty of Law, and 2004, the professor of Okayama University School of Law. The School of Law is especially, it is different from Faculty of Law. School of Law is the system and educational system and the organization to teach the profession, which means in future the student will become a judge and prosecutor and attorneys, especially professional school. And the 2011, Dean of School of Law in Okayama University. And 2015, I transferred again from Okayama to Hokkaido University here. I'm working at teacher and I'm working as a teacher of criminal procedure law in Faculty of Law and Graduate School of Law in Hokkaido University now. Okay, Now, okay, let's get started the explanation of criminal law. Before explanation of criminal code, I want to touch upon the basic structure of Japanese law at first. Of course, Japan is written and a statutory country, so we have lots of written laws in Japan. But as a basic law, we have 6 laws, kinds of laws. The first of all, of course, we have constitutional law, the highest position. This is the highest position. The constitutional law is basic structure of government and countries and politics and finance, national finance. This is a very important, most important laws among the written laws in Japan. And of course, substantive law, we have the civil law and the criminal code, in other words, penal code, and the commercial law, the enterprises laws. And as a procedure law, we have 2 kinds of laws. First of all, civil procedure code, and secondly, the criminal procedure code. And of course, my major is criminal law. So criminal code and criminal procedure code is the main field of mine. See, and of course, and the principle of constitutional law. With Japan, Japanese constitutional law has a very important principle of 3 kinds of very important principles. The first of all, principle of popular sovereignty. This is the main field. We Japanese people are the main of the country So if we, of course, we have freedom of speech and we freedom opinions. So if the government and politicians makes a mistake and want to make wrong laws, we are against that movement. So we have a rights to express their own opinion to parliament and the politicians because of a principle of popular sovereignty. Of course, Communist Party or other countries, the socialism and the communism countries is not so guaranteed. The speech of opinions, freedom of opinions, freedom of demonstration, and so on and so on. And the second is renunciation war. Theoretically, we don't have an army because, as you see, in the World War II, we have a surrender. We have a very long, we did a long war against Asia or the China. So as a reflection, we have give up the kind of army theoretically. But practically, we have self-defense forces, but we don't call that forces as army, not as self-defense forces. So our purpose is to keep and maintain the peace all over the world as the very important principle of our of our constitution, of Japanese constitution. It is a very important principle under the status quo. As you see now, we have a very serious situation in Europe, the Ukraine war. So this is a very important principle now. And third, the respect of the fundamental human rights. Of course, we have individual rights is very important, I think. So almost all of the Japanese are thinking that We are very, we human beings, center of the field of laws and social society. So our constitution preserve the human rights, individual human rights. This is the three important principles of our Japanese constitutional law. The fields of criminal law. Now I want to explain about the criminal law. Of course, maybe, probably, the Indonesia is same. We criminal law has three kinds of field. The first of all, criminal code, in other words, penal code, and second is criminal procedure code as a procedure law, and the third is third field is criminal politics. The criminal politics is not the law, but the politics is searching for the criminal codes or criminal to protect the policy to protect the criminal. And the criminal code has is divided two kinds, two fields. First of all, a general part, and the special part. I want to explain the content of later, two parts later. The criminal procedure code, criminal procedure, especially in fields of the criminal procedure, we have to research, we have to study the fields of investigation of police, and prosecution of prosecutor, and the trial and the judge. This is the main target of studying. And the criminal politics, as I said before, analysis on the cause of crime and politics against the crime. How can we protect the increasing of the crime? This is politics against the crime. So criminal law is constituted in three kinds of fields. And this is this chart shows us current situation of the crime in Japan. The number of crime. As you see, this is the purple graph with the very serious case, very serious crime, the case, the murder or rape or robbery and other and so on and so on. The very serious case is here. As you see, in Japan is a very safety country, so there are not so lots of very important criminal case in Japan. The tendency is not so change. Here is 2017. This is Japanese year, so, but in Western year, the 2017. So the very serious case is only 21, no, 215,000. So very little. And this is the yellow graph is including theft. The theft is Japan is lots of theft case, but serious case is not so much. And the content of Japanese criminal code, I want to explain about it. The contents of general part of criminal code. First of all, I want to explain. The general part of criminal code, we are analyzing the concept of the crime. For example, what is a crime? The concept of the crime. What is the definition of the crime? And second is what elements are necessary to establish the crime. For example, the act. What is the act? The criminal act or the criminal result. What is the criminal result? And act and the criminal result, between act and the criminal result, we have to find out the causality, and no existence of defense. To establish, to affirm the crime, we have to no existence of defense. And the public punishable age is important. Of course, we need the defendants is reaching at the punishable age. And intentional negligence, that crime is committed in intention or negligence. It is a very important point, etc. etc. And the third point, what is the attempt of offense? Of course, the serious criminal case is punishable against the attempt offense also. So reason of attempt offense punished. Why? Why the attempt offense is punishable? The fourth is what is a complicity? Of course, the criminal offense is committed not only one person, but also the several persons. So that is a complicity. So complicity, why and how to establish the complicity in crime. Especially, we are searching for what is inducement and accessoryship and core principles. These points are the main points of studying. And the second, the content of the special part of criminal code. As I said before, the Japanese criminal code is divided two fields. First of all, general part, and the second is a special part of criminal code. Especially a special part of criminal code has also three kinds, divided to three kinds. The first of all, crime against the individual interest, which means, for example, murder and bodily injury and intimidation and the rape, the theft and the fraud. This is the example, but these crimes against the individual interest. The second crime is against the social interest. For example, arson or the forgery. These crimes against the social interest, the social security is very these crimes makes social security dangerous. The third point is criminal against the national interest. For example, insurrection or corruption. These crimes against the interest of nation. So special part of criminal code is divided three kinds of three fields of criminal. By the way, the history of Japanese criminal law I want to explain. First of all, 1880s former criminal code. That criminal code was influenced by France. At the beginning of Meiji era, about 550 years ago, Japanese government wanted to introduce the theory of Europe, especially France is a textbook of criminal law. 1998, the Constitution of the Empire of Japan. As you know, Japan was empire. Has a very big power and has a very big power of influence to the Japanese people. So Constitution, the content of the institution is reflected the power of empire, Tenno, the Kaiser.
Right.
The 1907 the criminal code, the influence of Germany. Actually, to tell the truth, at the beginning of Meiji era, 500 years ago, France had a very big power to the Japanese government. But after that, Germany had very big influence, big power against the Japanese government. So many politicians went to Germany to study the theory of constitutional law, and not only constitutional law, but also criminal law and criminal procedure law. So, but the 1945, end of the World War II, this was a very important point of Japan. The change of the law thought, the occupation of America, GHQ, General Headquarters. As you see, Japan was influenced by America after World War II. At that time, 1945, Japanese Criminal Code Amendment Party, German laws influence. The constitutional law, Japanese constitutional law was influenced by America, but surprisingly, and I don't know why, after World War II, Germany had a very big influence against the fields of criminal code. So many Japanese professors whose specialization is criminal code goes to Germany now also. Not only many few scholars goes to United States to study the fields of criminal law. Okay. The character of JCC, Japanese Criminal Code. As I said before, as I say, German criminal theory is a strong influence to Japan. So written law, interpretation of the text, the fields of interpretation of the text. For example, the Article 199, that is a very important article in Japanese Criminal Code. A person who kills another person is punished by death penalty or imprisonment for life or for definite term or not less than 5 years. This is a murder article. So, of course, the professor of criminal code is interpreting what is a person, or what is a kill, or and so on and so on. And of course, Japan has capital punishment. So this penalty we have. Indonesia, do you have a capital punishment also? So Japan has also a capital punishment, death penalty. So it is a very serious and disputed problem now. Another example, for example, Article 235. This is a theft. This is the article concerning theft. A person who steals the property of another person commits the crime, blah blah, and so on and so on. But the professors of criminal code is studying what's the content of steals or property, or Article 236 and the robs, and Article 246 and defaults. Now, for example, the text of the words, the robs or the defaults, what does that mean? Meaning, the criminal codes professors interested in this interpretation of these words. The requirements of the crime, and okay, and I will explain the establishment and the requirements of the crime to affirm. First of all, we have to find out objective elements. For example, criminal act, a criminal result, causality, attempts. These fields, in these fields, the professors studying and the searching the content of act or criminal result and the causality and attempts. And the second is the defense, justifiable acts and the self-defense and the necessity. If these requirements fulfilled, there is no crime. And the culpability. If the government and the judge, the court wants to punish against the defendants, Of course, a defendant has culpability, the intent or negligence, competency, or punishable age. These elements are examined in strictly. I want to show the chart to establish the requirements of crime. First of all, the objective elements and the defense and culpability. These elements are food at first, food. So as a result, criminal is established. But of course, the objective elements and the defense and the capability, lack of these elements, this is no, we can affirm not crime. These acts are not crime. We estimated. So, for example, justifiable act. What is a justifiable act? The Article 35, an act performed in accordance with laws and the regulations in the pursuit of lawful business is not punishable. For example, the boxing. Of course, this is the injury. But of course, this is accordance with laws and regulations, so there is no crime. We can't affirm that act as a crime, of course. And the 36, self-defense, an act a person was compelled to take to protect the rights of oneself or another person against imminent and unlawful infringement is not punishable.
Yeah.
The other persons are going to attack the counterattack. I injured him, but this is not. We cannot determine, judge that this act, the counteract, is a crime. Of course, because to protect my rights. So
this include if someone will rape some woman and the woman fight back. And that's okay.
Right. Necessity, that is very difficult to explain. To show the chart, the one person is on the sea, but what is travel だからthe one person catches the wood and another person wants to also catch the wood. But at the same time, two persons catch the wood at the same time, but the wood is sinking. So one person is against attacking against the other persons. The other person died, but this is not a crime because it is he cannot avoid to save my life. So this is not a crime. We judge this all. Indonesia is also.
We have this regulation.
This is a very important situation. Of course, to establish, to meet the requirements of the crime, the intent to act is very, very severely punished. The Article 35, an act performed without the intent to commit a crime is not punishable. Of course, if the one person is going to the intention to crime, it is necessary to establish, to meet the requirements to establish the crime. Of course, an attempt is also punishable. The Article 45, an attempt is punishable only when specially so provided in the article concerned. As a negligent act, the criminal result is very serious. The attempt to crime is also punishable. But negligence act is exceptional. It is not principle. It is as an exception. The attempt to crime is punishable.
That the sanction also to decrease for this attempt.
And the protect of the legal interest and the object of punishment, criminal act, and sword or immoral acts, etc., is not unpunishable. Japanese and cannot punish the defendant. Whatever the defendant has a very wrong sword and a very immoral act, but it is not a crime. And the guarantee to freedom, the principle of legality, nulla poena sin lege, that is Latin, because it is what is the crime and how how to punish. It is determined and as a written law before. This is protects the freedom of the Japanese people. And the due process of law is also, if the judge wants to punish the defendant, the process of criminal procedure law and the criminal code is clearly determined and very strictly proceeded the criminal code, criminal trial. These principles, the concept, we can say that consequence of democracy. Democracy is a very important principle of Japan. Politicians who has a very big power of freely punish against the Japanese people is not also a strong prohibited. Sorry. The criminal code. Okay, summary. I want to go to summary. First of all, as a criminal law, the criminal code and the criminal procedure and the criminal politics, these fields are constituted as a criminal law in Japan. Of course, my major studying field is a criminal procedure, but of course, I'm studying criminal code also, and the criminal politics is a very special area. So I don't study these criminal politics not so much. The second is the criminal code. The criminal code is divided into two parts. The first of all, a general part, and the second is a special part. The general part is has a content of analysis of general requirements to the crime. What is a crime and what is act, and what is the causality, and what is the justification, and so on. And the special part is many kinds of crime is divided three fields: the analysis of each crime act and interpretation of the text. This is a law book and law book. This is law book, and we have to use to interact with the words of the criminal code. This book by using this book. The requirements of the crime. The three requirements must be filled to the crime. So first of all, objective elements and the defense capability. If the defendant is lack of these crimes, a defendant is not punished. And the function of the criminal code, the protector of the legal interest, of course, national interest and the social interest and individual interest. The criminal code must preserve these interests. The guarantee to freedom, because as that result, the criminal code plays a very important role to protect the guarantee to freedom. Now, okay, that's all my explanation of Japanese criminal code. Of course, if you have some questions, please feel free to give me questions without hesitation.
Okay, thank you. Ueda. Ini untuk saudara sekalian bisa mengajukan pertanyaan bahasa Indonesia. Nanti we can translate to bahasa Inggris. Okay?
Okay.
Who have you please if okay, you can write in chat room or you can raise hand and give the answer.
Can I be the first questioner?
Okay.
Okay, first of all, thank you so much for the fruitful discussion and presentations made by you. I think it's like the regular events, right? Organized by our university. And we hope, before I go to my questions, I would like to give the compliment, and also maybe we can make our collaborations more fluid.
Sorry, please speak slowly.
Slowly.
Okay.
It is
Okay. First of all, I think that I would like to appreciate what we have been done so far, the collaborations between the Hokkaido University and Universitas Bengkulu. And we hope that the collaborations or the partnership will be more closer, not only invite you in our university, maybe one day you can also invite Professor Herlambang to come to your university to
sorry, Thomas.
Yeah, some trouble. Yeah. some okay. Ari, maybe it's not good connection, you know. Some time, weather, and many reasons.
Is not good.
Yeah, yeah.
Tomato stop, okay. Other students is okay. Are there some students to come to Japan before?
Yeah, Ari. Oh, she live some. Okay. Ari. Okay. Amelia. You like my student Amelia. She is the judge. She will ask you. Yeah. Yes. Please, Amelia.
Okay, thank you so much for the opportunity. I want to ask Mr. Professor Sintaro Ueda. In Indonesia, during the COVID-19 pandemic, we conduct electronic trial that called e-court. Now, I want to ask how about in Japan, about the implementation of criminal court in Japan, as the same as in Indonesia, doing electronic trial. Thank you so much.
Okay, but is the answer for tomorrow? I think, but no problem. You can ask. You can answer Ueda Sensei. You know, the trial without. You know, we use the IT to trial. The defendant not come to the court. You know, we have regulation until the COVID. How in Japan?
Excuse me. I didn't understand exactly the Miss Amelia's question. Your question is concerning about criminal procedure law.
Yeah, criminal procedure. Then I say that the answer should be tomorrow. But you can answer that.
Miss America is Miss Amelia is judge of Indonesia.
Yeah.
So your question is about criminal procedure law. Excuse me, if it's okay, please write down your question is chat box.
Okay.
Maybe I'll try that to explain about the Amelia questions, Professor Ueda.
I want to answer.
Okay.
If it's okay.
Okay, Ari.
Okay. Before going back to my questions, I think the questions made by the Amelia is about, does the criminal law procedure in Japan accommodate the electronic trial since the pandemic issue? Because in Indonesia is one of the a new initiative made by the judiciary power to compare between the conventional one, criminal law procedure to the electronic law procedure. So does the Japanese legal system or Japanese penal code also accommodate the electronic trial to the pandemic? It is the questions made by the Amelia. Going back to my questions, sorry.
Okay,
before...
maybe the first from Amelia. After that, you can ask her. Okay, thank you. Please.
I offer.
Please, Ueda Sensei.
This is a very good question. Nowadays, under the status quo, the electronic judicial system is examined in Japan also, but it is not so proceeding now. Of course, in some fields, we are introducing the system of electronics. For example, video cameras, cross-examination, or and the audio-visual using to explain the situation of evidence, and so on and so on. But it is not so proceeded under the status quo. But of course, now Japanese government and the committee, the Ministry of Justice, is examined and they are discussing about the warrant, the electronic warrant as America.
No, you use the Zoom for the trial in court? No, the defendant should be come to the trial. Okay,
but the situation is the civil code is different from the criminal code. The civil code is proceeding the IT or the IT or electronic system proceeding the criminal code.
That means in criminal court, you not use Zoom. Okay.
The defendant must come to the court.
Yeah, maybe I like to explain the situation. Japan, not like Indonesia. You know, Amelia, in Indonesia, many case, but in Japan, it's very small case for the criminal court. Maybe in like Kagawa, in 1 month, maybe they not occur, the case not occur in court. That's true, Ueda Sensei?
Yeah, right.
Yeah.
Do you have how many judges in Indonesia under the status quo now?
Berapa Amelia? Kira-kira jumlah hakim seluruh? For example, in Amelia Jati in some district court, di mana berapa orang?
Di mana ada 9 orang.
In one district court, they had 9 judges to handle the case. Yeah, for one district court. Yeah, but in high court, they have maybe 20 judges, and the Supreme Court we have 50 judges. Yeah,
50.
Yeah, 50.
50. Oh,
yeah,
very strong.
Yeah.
In Japan, the Supreme Court is only 15.
Yeah, you know.
Supreme Court is 1.
Yeah.
Jakarta.
In Jakarta, yeah.
50.
You know, 50. This is not enough because the case is very much case, and now we should a problem concerning the delay of process. You know, if sue to the Supreme Court, maybe they need 1 year or 2 years to make some decision. Yeah, maybe we can add the number of Supreme Court judges in next time.
Are there lots of female judges in Indonesia?
Yeah.
As Amelia-san, Miss Amelia.
Amelia have a friend yang perempuan berapa orang di situ?
Ada 6, Prof.
Yeah, in Amelia district court, they have 6 person from the 9 judge is a woman.
Oh, really?
Yeah.
Oh, wonderful.
Okay, Ari.
Ari-san.
Okay, thank you so much. Sorry for the some trouble by the signal. I just want to going back to my speak first. Yeah, I would like to appreciate and giving the compliment for this collaborations, Matt, and hope that it will be further. Maybe one day Professor Herlambang can come to Hokkaido directly or indirectly to also present about the Indonesian criminal law, so make our discussions more rich and rich in terms of the comparative itself. My questions is about, as you mentioned, two of the principles in the constitutional of Japan is about promoting the human right, right? And also the people sovereignty or popular sovereignty. And now currently in Indonesia, there is the revisions of the penal code made by the parliament, but there is discussions or the controversy regarding the article of insulting the head of state. So then I just wondering how then the criminal code of the Japan regulate about the insulting the head of state article in your penal code or criminal code itself. Then how to make it balance between this article, the insulting president or insulting the prime minister in your country with the democratic vibe or atmosphere. Whereas we know that the freedom of speech, freedom of expression is one of the article or a norm that guaranteed by the international, and also because we state our country as the democratic and the human right or rule of law. So how make it a balance between the article insulting the head of state and how then to guarantee the freedom of speech itself? It is the questions in your perspective or in your criminal law criminal law article. Then the second question is about the blasphemy article. I just wondering that how then the penal code of the Japan regulate about the blasphemy article. Because in Indonesia, there is some issues regarding the blasphemy based on the religions and so on and so forth. Then the government trying that to put some article into our penal code itself. Then I just wondering how then your country regulate about the blasphemy article of revision itself. I think that's all. I over the microphone to Professor Herlambang.
Okay, thank you. Ari asked that how the Japanese criminal code regulate concerning the insulting or say something bad to the prime minister or the emperor or the local government. You abandoned it? You in Japan code?
Sorry, once again, I want to confirm the content of Mr. Professor Ari's question. Emperor and Prime Minister Abe,
yeah, not kill, but only make some say bad thing to Prime Minister or the Emperor. You regulate that to in criminal code.
Betty, what is Betty?
Bad.
Something bad, like the critic. Oh yeah, critic the government very seriously. I mean that. Does your penal code regulate about insulting the head of state article or insulting the emperor or the king of the Japan? How then the article regulate about insulting the head of state itself in your criminal code system? Because in Indonesia, there is the debate between the article on the insulting the president with the atmosphere of democratic and human right. Because, you know, right, the freedom of expression, freedom of speech,
Sorry, it is
under our constitutions, under our constitutions and okay.
ハラマンさん、ちょっとコミュニケーション it is difficult to understand that because of situation of Zoom.
Yeah.
安倍さん、Mr. Prime Minister Abe or the Emperor is against, is killed.
Yeah. No, not kill, not kill. Say something bad. Say something not good. For example, I say the prime minister is make corruption, but he not maybe I say maybe the emperor is immoral. Like the speech like that you regulated in Japan criminal code. They give sanction for that act.
Yeah.
Yeah.
Regret. Yeah. Japanese criminal code regret.
Okay. Yeah, because in Indonesia now it's very the student, of course, special. They don't like Ari told, we have make some new criminal code now. In one of article try to what melarang apa ya? Lupa saya. Ari?
Prohibit.
How is the penal code?
Prohibit.
Prohibit.
Melarang prohibit.
Prohibition of the if we make a critic to the government, like Japan too. Why did it become a problem? Because this is against the democracy. The people have a right to speech, but the criminal code abandoned it, prohibit that. How about you seeing that?
Very slightly question. It is very difficult to answer. But of course, criminal code express a regret to the Prime Minister or the Emperor. Officially, it is prohibited to express their own opinions. But the courts is one of the national organizations. So, of course, Supreme Courts, the chief of the Supreme Courts express the regrets to the, so for example, Abe case or Emperor's it is a very difficult question to answer. Sorry, Ari-san. Tomorrow I want to explain about it once again. Sorry.
Okay.
Does Japan? We have a chat. We have a question in chat function. Several questions. How the penal code of Japan regulate about insulting the head of state or the king? そういうこと。これ、of course, it is very punishable. Punishable. But the head of the state, the prime. So here, the head of the state is Prime Minister, the chief of cabinet.
Only for the Prime Minister and Emperor, not in local government.
No, of course, insulting
local government is punishable too.
The head of the prime minister, the other governors or kings are the same position as other normal Japanese people. So if insulting, if one person insults the prime minister or the Kaiser, the king, the emperor, of course it is punishable as the same as popular person, popular Japanese people. So the prime minister Abe is stupid or say something, but it is if the saying, the insulting conduct intervene the rights of the owner of a prime minister or a king, it is punishable. Generally speaking, it is not. It is very difficult to establish the crime as that conduct, because the prime minister or the governors has a tend to be criticized.
That many case in Japan? No case.
Not case.
Okay.
Of course, newspaper or TV news has a tendency to criticize against the prime minister or cabinet members or the district governors, because this is a democracy.
Yeah. But it's a different situation in Indonesia now.
Really?
Government try to punish the who criticize him, not only the government, the central government, but also the local government and or the branch of the power. For example, not executive, not legislative, representative body, and the judicial. If we have insulting, all of that will be punished.
Of course, Indonesia has a freedom of speech.
Yeah, but now in this era, more some restrict.
Really? So I'm very sorry.
Yeah.
In China, it is a very slightly question, but of course, communism countries or socialism countries, it's very difficult to criticize the governance and the politicians.
Yeah. In our regulation, we are the law state, but in the practice, some of power who have a power try to restrict, forbidden the critic. Okay.
Of course, because a democracy country is subjected to law, man of law. Rule of law. Rule of law is important principle, important value.
Okay. Okay. The next maybe Milda, Rasan, please. Okay.
Okay.
Thank you.
Please.
So first of all, I would like to say sorry if I don't speak really good, but so related to the question from Mr. Ari about the prime minister got shot last time, and according to some news that I read, that actually the bodyguard itself not aware about what happened at that time, and it makes me wonder, is that actually really free for the citizen to criticize the government, or maybe there is suppressed by the monarch or the government itself to the citizen, so they don't really criticize the government? And so because of what happened, so I really wonder, is there any regulations that the government made for the citizen that limited the citizens to criticize the government or the monarch itself? Like if we see that in Thailand, the citizens can't really express themselves to criticize the government or the monarch itself. Thank you.
Yeah. Continue the question. That you have regulated to forbid to express another option to the emperor or government, critic to emperor and government.
I want to confirm once again And Ms. Milda-san's question is about
like in Thailand, they forbidden the express and the critic to emperor. In Japan too.
Yeah.
No say, don't say something wrong and bad to the emperor.
This is a very difficult and slightly question too. Of course, Japan is a very special country in terms of emperor.
Yeah.
If the national people, Japanese people, is against the criticize system of emperor, it is very, very dangerous. So we don't have a freedom of speech in the fields of emperor. It is very, very difficult and dangerous for me, for us, the Japanese people. So of course, some group, some people, some people who belongs to radical group is criticizing the system of emperor, but it is not itself. It's not punishable, and it is not crime. But social attack occur against such a people.
No people talk about that.
Some people say. Some people.
Okay.
Very little.
But it's not a crime. Okay.
Not crime.
Okay.
But
okay.
Of course, some people are attacking the emperor. It is a crime. They're punishable.
Oh yeah.
Only express our own opinion against the emperor system. It is not a crime.
Okay. Yeah. Okay, Putri Rahmadanti. You can speak, please. Rahmadanti. He's right in Indonesian bahasa. Okay, I try to
PR, Miss PR, easy. No, this is the Indonesian.
Ya, actually, Rahmadanti, silakan kamu, maksud kamu apa tuh? Silakan bahasa Indonesia saja, please. Say to Indonesia. Putri?
Baik Pak, izin bertanya. Saya izin bertanya apakah...
Ya, they speak in bahasa. I will translate for you. Oke, silakan.
Apakah pengadilan pidana di Jepang itu mengadili kasus pidana itu sama, maksudnya hanya melihat dari undang-undang atau peraturan tertulisnya saja, atau sama seperti misalnya di belajar filsafat kan kita bisa melihat hukum yang tidak tertulis. Nah, Durian, apakah di Jepang itu hakim itu memutus atau menjatuhkan hukuman itu hanya melihat apa yang ada di peraturan, bukan melihat besar kecilnya ketika orang itu melakukan kejahatan tadi, Pak.
Oke, thank you. Ya, Putri asks you that in Japan, the judge will make decision only based on the regulation, or like Indonesia, I told you yesterday, we have the unwritten law, the customary law. Okay.
Very good question. As I said before, Japan is a written statutory country. So Japanese criminal judges don't depend on the unwritten rule we have to, the judges, all of the judges in Japan, depends on the law だからなんていうの、law book, the regulation book. So there is no room for Japanese judges to depend on the customary law or unwritten laws and so on and so on. Okay.
Yeah. Well, for example, if somebody steal the bread, for he like to eat the bread, and she steal the bread, that also will be punished.
Bread? What is bread?
Bread. Rice.
Rice.
Okonomiyaki. She steal okonomiyaki or something. That also will be punished.
Of course. Because the theft article, someone, if a person steals the property, it is punishable as theft. The
pen or little.
Of course, this is the property, so it is punishable as theft. But of course, this is not a serious case.
Yeah.
Serious case. So at the end of the judge, it is a very, very slight case and not serious, so unpunishable. There is a room, and the judge decided. Maybe judge decides this case is not so serious, so it is not. This is crime, but not punishable.
Okay. Yeah, it's maybe in Indonesia too, but we have the from the Supreme Court, from the prosecutor and police headquarters, they have rule to not bring the petty offense, to the court.
Yes, of course.
Okay. Our lecture too in chat room, Dr. Simandahwan, and he asked, like your presentation, that some of termination, we have some termination. Yeah, maybe from of course Indonesia, the history of criminal court in Indonesia, they're from the Dutch, that from the French, France. Maybe the early time we have same the regulation concerning the criminal code. Of course, the book 1 of general rule, we have maybe not only Indonesia and Japan, in many of states they have many similarity, yeah, Indonesia and Japan. Yeah, that can you tell the history that like the history of criminal code? Now you have new criminal code or no? From 1907 from the before Independence Day?
Of course. Of course.
Yeah.
Indonesia is imported the theory of Dutch theory, including.
Yeah,
because,
but
Indonesia is one of the colonies. Historically speaking, Indonesia is colony of Dutch because of that.
Yeah, but now we have make some reform of criminal code, and not only from the Dutch, Netherlands, but many from the America, of course. In Japan, we make some rule. For example, in Japan, you have two parts of criminal code, general and special part. And Indonesian criminal code, the all Indonesian criminal code, we have 3 parts. Yeah, general rule. What I not remember, but we start three part. Now we change to become 2 part.
2 parts.
General rule and special rule, and some of argumentation that some discussion concerning the corruption regulation. Some group, they don't want regulation of corruption become a part of criminal code. They want the corruption rule is this not part from the criminal code, the special regulation. Yeah.
Which countries does have power against to the Indonesian criminal code? America.
Now we make many of our from German too, because our scholar read many book from the German too. Tabestan, like that. We understand what the termination of that.
It is very interesting.
Okay.
Sorry, I just joined this lecture because
Prihartini Ningsih. Oke, silakan kalau ada mau ditanya. Or another, please.
Okay, thank you, Prof.
Silakan.
Okay.
Bisa. Oke.
Ya, baik. Thank you for information, Mr. Ueda. Let me to give you with you about the system of criminal. According of me, the historical system criminal of law in Indonesia and Japan is the same because we are the system Europa continental transfer from Holland system. In many books about the law, much of information from lecturers and scientists of law give information about the system of law Japan, not so different with Indonesian system, because Indonesian system there is traditional system, religious system, and after that we continue combine about the national system. National system in Indonesia it is the name of KUHP. Now the situation criminal of law Indonesia, like information just now from Prof. Herlambang, there is reform, but still debatable, not definitive, not definitive decision, still debatable information. In order then, according to me, Indonesia system still use with the Europa system, continental system, or Holland criminal system of law. It is good for you or not? Please explain to me. I want to know seriously, because Mr. Herlambang, Prof. Herlambang, always consist of about the consist of the law between Japan and the other country, like American system of criminal, German criminal, and then our intent to follow about the information. Thank you, Prof. Herlambang. Please you translate about my minding.
Okay, thank you. Okay. Dr. Sirwan say that, of course, I forget to say that in Indonesia, we have many of criminal law. First, the national criminal law, this influence from Netherlands, of course. Secondly, we have customary law, criminal customary law. It's used in village, chonari, yeah. And the third, we have the religion criminal code too. In some of Indonesian area, for example, in Aceh, the prefecture of Aceh, Aceh Keng, they have religion criminal code based on Muslim religion. Yeah, you maybe you can compare in Japan. Japan only have one of national right. You have no customary and religion. Yeah.
In Japan, there is no room to accept the religion and the customary law to interpret the content of the criminal code.
Yeah, I remember the Ari question that concerning religion.
Religion.
If you in Japan, you have some regulation to prohibit it who make something bad or wrong to the religion.
But of course, to confirm and to make clear what is a wrong religion and a bad religion, it is very, very difficult to draw the line between good religion and bad religion. So, of course, there is a freedom. We have a freedom of religion in Japan. So,
when I stay in Japan, I look some of the price. Price. The traditional Japan use is like kimono and big. That religion, what you say, what you call that? Japan religion?
Yeah, religion. Yeah. Custom.
Yeah, or custom. If somebody insulting the price of Japanese tradition, this is prohibited in Japan.
Yeah. No.
Yeah.
No, prohibited.
Oh, prohibited. Okay. Thank you. This is a question from Prof. Herawan. In Indonesia, restorative justice policy is currently being developed. Yeah. Is a criminal settlement based on restorative justice the same as settlement based on customary law? Now, Professor Herawan stay in Istanbul, like our dean too, Amanci in Istanbul now. But she asks, you have some, like I told you before, concerning the restorative justice. You use the restorative justice in Japan?
Restorative justice is very becomes popular in Japan too. So mediation is very important. Mediation is very important between offender and the criminal victim.
Yeah.
But some professors insist the restorative restorative justice. It is not popular yet. The punishment, the essence of punishment is to punish.
Yeah.
So of course, I myself support and for the restorative justice. We have to furthermore the restorative justice in the field of criminal justice system in Japan also. But it is difficult for most of the Japanese to accept the restorative justice policy.
In Indonesia, it's more easy because we have customary law. Customary law based on mediation too. You know that now our like today we have some seminar too in Faculty of Law concerning the restorative justice.
Yeah.
Now we have two of seminar in now this is and another seminar in restorative justice.
Of course, in the restrictive field of criminal law and the criminal the situation is restorative justice. There is room, some kinds of room to play a role in terms of restorative justice policy. For example, theft or insulting, or especially individual interest fields.
Yeah,
The murder or robbery and other serious cases, of course, it is difficult for the justice system to work well in Japan.
Same in the heavy crime, we not use the restorative justice, but petty crime, of course, we try to use the restorative justice. Okay.
Of course, for example, a defendant who kills the former Prime Minister Abe can't be admitted. There is no room for him to accept for Japanese people. It is very, very condemned.
Yeah. Of course, Okay. Another question, please.
Don't forget to visit.
So Ari said to the Professor Herawan, kapo ke dia in Turkey, yeah. This is Professor Herawan. Yeah.
The city name Cappadocia.
Yeah, Cappadocia in Turkey. Yeah.
Oh, yeah. Thank you very much.
Okay.
Thank you very much.
Okay. Another question?
Because of my poor English ability, so sometimes, of course, you will confuse my lecture, the content of my lecture. So
no, be clear. But maybe my student not because they not like in many of class. Okay, Priyatiningsi, please. Okay, Priyatiningsi. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Okay.
Terima
Silakan,
kasih,
Bu.
Pak Bambang. Thank you very much. I just say sorry that I just joined this general lecture because I just know the announcement about 20 minutes ago when I opened my my mobile phone. So I'm so sorry that I didn't follow the first part of the lecture, but I want you to know, Professor Ueda, that actually I'm not law woman. I'm coming from agriculture faculty,
lecture of
just
agriculture.
Like his wife, Bu Marlin, jadi so I'm
of my mind.
Plant protection department in agriculture of University of Bengkulu, but I'm so interested in this lecture because I want to know about the law in Japan that I know, just correct me if I'm wrong. I know that in Japan that not so many inmate person in prison, I think. Yeah, because a long time ago, I read that in Japan, if you are doing wrong something in criminal, you just forced to mengaku ya. Mengaku Pak Herlambang apa itu bahasa Inggrisnya ya. Jadi so I lost the word. Just yes, you jadi lebih baik mau ngaku sehingga proses hukumnya menjadi lebih berjalan lebih lancar gitu ya. Tidak berbelit-belit seperti di Indonesia sehingga tidak banyak orang dihukum dan proses penegakan hukum di Japan ya. I think that how Japan what doing the law is better than in Indonesia, I think. So ya, selain itu masyarakatnya sudah begitu sadar hukum ya. Mereka misalnya dengan tahu di mana batas-batas yang boleh mereka lakukan dan yang tidak boleh mereka lakukan gitu. Misalnya menyeberang jalan pun mereka memberi hormat atau memberi apresiasi to the person that allow them across the street, even they are still a child, for the school children. So I want to know how about the prison in Japan? Actually, there are there so crowded, but I don't think so. Because I believe that there are not many inmates in Japan prison. I think not so many prisoners. So I want to know about that. Can you would you mind tell me or tell us about how many people in the prison in Japan? Say like in one district you have maybe a prison, and then how many prisoners there, so like that. Because here in Indonesia we overload the prison because so many people dijatuhi hukum ya Pak ya. Ya gitulah. So probably you can tell us about how law in Japan so make people there so happy and not so many people have to stay in prison or as a prisoner. That is what I want to know from Professor Sintaro Ueda.
Okay, thank you.
Thank you very much.
Thank you. Ibu di Prihartini
call me as Ning, Buning.
Oh, Buning. Buning is the lecturer of agriculture.
Yes.
But he interesting.
Plant protection department.
She interesting concerning the law. And general lecture open for the another our Civitas Academica. Okay. He asks, like a different phenomenon in Indonesia now, the prison have many prisoner stay in prison, crowded prison.
Overload.
Overload. Yeah, overload of prison. Then in Japan too, you have overload. Many people, many prisoners in prison.
In prison, yeah.
Yeah, in prison.
In prison, yeah. In prison.
Yeah, many prisoner in prison, a Japanese prison.
Is there overload of prisoner in your prison?
In prison?
Prison.
Prison.
Yeah. The place which the place for the inmate. You know, inmate. If somebody finish the process of criminal and she punished, he should be stay in the prison. Yeah.
Imprisonment.
Prison. Prison. Hi. Many people in prison, Japan prison.
No. The Japanese criminal situation is very better than the Japanese criminal situation is very good under the status quo now. So the number of imprisonment is very decreasing. So as I say, the Japan is very criminal occurrence ratio is very low. We are so many prison, but the people in prison is very few.
Yeah.
Especially at the beginning of 2000, it's a very a lot of prison people.
Population, yeah.
It is a very few.
Every gang have a prison. Every gang have a prison institution.
Yeah. Yes.
Oh, but no people stay in that prison. Yeah. Very few. Okay.
Oh, very few. Okay.
Yeah. Okay.
So many people.
So some prison. Closed.
Okay. It's different situation in Indonesia. You know, many prisoners in prison. You know, overload. The one of block it should be in for the 15 people, but now we have 14 people or more than.
Really?
Yeah.
Very serious.
Yeah, of course, that's a reason why we have to support restorative justice, because don't send people to the prison. Yeah, because prison is overload. Yeah. Okay. Okay. Another another question.
No.
Okay.
Hello. I want to ask once more question for Professor Ueda.
Yes.
Yeah. Nice meeting you, Professor Sintaro Ueda.
Hi. Me too.
Yeah. I want to know about how about the opinion of the Japanese about if someone doing wrong, and then he or she have to go to prison. What is the opinion of the Japanese?
Sorry, to confirm your question, what is the opinion of what? For what?
For the ex-inmate, if somebody exit from the prison, how the people will accept them in society? The people will accept better for the ex-inmate.
It is a very good question, but of course it depends on person. It depends on person.
They, for example, they will accept to work in some place. Nobody will reject him or she.
of course, most of the Japanese people, normal people,
Conception of
reject
society.
the person, reject the former defendant and the criminal. So
Okay.
it is difficult for him to find out the job place. But of course, some people accepting that person because to re-socialization.
Okay. Yeah.
But your question is very, very important in Japan now.
Yeah.
Okay, thank you, Bu Ning.
Yeah.
Bu Ning.
Yeah.
Okay.
Yeah. Thank you, Mr. Ueda and Pak Herlambang.
My pleasure. How
Nice
about
meeting you.
Indonesia? How about Indonesia?
Yeah, of course, in Indonesia too, the first problem we have many of prisoner. There's a problem. Now, the secondly, if they exit from the prison, they make some another problem again. Like in criminal politics, of course, in criminology, we have labeling theory. They will be labeled as the bad man, Everybody not accept them. They need some time to make people accept them in society. This is a problem,
But most of the Japanese are not tolerate with the criminal.
Yeah.
So it is a difficult question and a difficult problem to resolve.
Yeah. Okay. We have 5 minutes more. If another question, please. If not, I like to give Professor Ueda give.
I think Professor Emilia Contessa is already raised their hand.
Okay, silakan. Please, Dr. Emilia Contessa. Yeah. Director of Notariat Program. Okay, silakan.
Thank you, Prof. I have one question. I'm just wondering about obedience to verdict made by the court. Does society in Japan obey the verdict, or is there any disobedience on it? Thank you, Prof.
Obedience.
Yeah.
You think concerning legal award? Legal award?
Legal war?
His question is about the compliance or obedience to the verdict decisions made by the court itself. Does the society in Japan always obey or follow the decisions made by the court, or there is any objections made by the society?
All of people accept the decision of the court in Japan?
Yeah.
In Japan.
Decision of a court.
Yeah, decision of a court. All of people accept that? No reaction? Sometimes the people will reject the court decision because it's not fair, maybe.
So it is also depends on case. Of course, some criminal court judge is very, very difficult to accept. But of course, some criminal case is a very nice judgment. So now it is very difficult for me to explain about the very, very unacceptable case. Of course, but there are some cases it is very, very difficult to accept.
Okay.
Especially rape case.
How about Japanese people think about the rape? You should be The sanction is very heavy for the rapper.
Heavy on the paper on the
That penalty, no?
no.
Or prison, yeah. Okay. Okay. Dian, you have here before we close the session. It's better if we make a photo, you know.
Okay.
Dian.
I can still want a question from the
Sasandra. Okay, one question from Sasandra. She is a prosecutor.
Oh, really?
Yeah, Master. Please, Sasandra.
Thank you.
This is uniform of prosecutor in Indonesia.
Oh, really?
Okay.
Thank you,
Please.
Prof. Sebelumnya, Prof, mohon ditranslate, Prof. Ini pertanyaan saya, Prof.
Okay.
Saya ingin menanyakan apakah di Jepang ada penyertaan modal dari pemerintah terhadap perusahaan-perusahaan. Contohnya kalau di Indonesia kan BUMN dan BUMD, Prof. Nah, jika direktur perusahaan melakukan perbuatan di luar kewenangan atau anggaran dasar perusahaan, untuk di Jepang bagaimana permintaan pertanggungjawabannya, Prof, terhadap direktur perusahaan? Apakah diselesaikan secara perdata atau pidana? Karena kalau di Indonesia kan sebagian besar secara pidana atau tipikor, Prof. Demikian, Prof.
Okay, thank you. This is concerning corruption case. Then, of course, this concerning the corporate responsibility, corporate liability. If some corporation which is done the criminal act, they will process in criminal court or in the civil court.
Yeah.
In Japan, yeah.
Of course.
And process in criminal court?
Yeah, that's right.
That means
in this case, the chief of corporation is coming to a court.
Yeah, yeah. That means the corporation, of course, the leader of corporation subjected to the criminal court, especially in corruption.
Yeah.
We can say that the businessman will become a suspect of corruption. Yeah.
Of course, the corporation has a legal personality.
Yeah.
So if the corporation has committed a crime,
yeah,
chief of the corporation as a defendant comes to the court, or the businessman belong to that corporation, of course, comes also as a defendant.
Ya, oke, ya, Bu Sasandra. Jadi dia termasuk juga sebagai subjek dalam dalam hukum pidananya. Oke, ya. Oke, another, maybe we can finish this session. Okay, Arya, you can conclude this discussion. Okay, thank you very much.
Okay, thank you so much for giving over the microphone to me, and thank you so much for the fruitful presentations and also discussions made by Professor Ueda. I think that there is many insightful and knowledge that we got from these conversations or these presentations regarding the comparisons between the criminal issue in the Japan and in Indonesia itself. So without further ado, I think I would like to close this event officially, and we hope that we can see you in the next day, right? For the another topic is about the procedure in the criminal law itself in the Zoom meeting. And I hope that the next years, in the 2023, we can meet you in person in Bengkulu. I think it will be nice discussions that we can meet or organize in Indonesia, in Bengkulu particularly. Thank you so much, Professor Ueda, for many things that you already given to us and your presentations. We hope that our collaborations or the partnership will be more closer and further. We hope that we just not only talking about the criminal law, maybe you can invite professor from the civil law, then collaborate with Dr. Emilia Contesha in the civil law department and maybe the constitutional law, so we can make many discussions regarding the comparisons between the Japanese legal system and Indonesian legal system in another topic and another discuss or another issue. So again and again, thank you so much. I close the event and thank you so much for all participants, and we hope that you can join back for the next event tomorrow with the Professor Ueda again. So thank you so much, and I close. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you.
From me too.
Yeah.
From me too. I will express sincere thank you very much for all the participants of this lecture. And I'm looking forward to meeting you tomorrow. Tomorrow is about criminal procedure, my specialization. So, but tough task for me to explain about the Japanese criminal procedure law in English.
Okay. Okay. Thank you very much.